On a Tuesday morning in March, a retirement account worth $420,000 sat inside a well-known brokerage firm. The account belonged to a woman named Carol. Carol did everything right. She contributed for 31 years. She never touched the principal. She retired at 65 with a number most people only dream about. Then Carol died in her sleep at 73. Her daughter assumed the money would come to her within days. Instead, that $420,000 went to Carol's ex-husband, a man she divorced 11 years earlier and never spoke to again. Nobody broke the law. Nobody committed fraud. A single outdated form did all the damage. This is the part of retirement planning nobody explains to you in plain language, and it is quietly wrecking families across this country every single day. Retirement accounts do not follow your will. They do not follow your intentions. They do not care who you loved, who you forgave, or who you meant to update. A retirement account follows one document and one document only: the beneficiary designation form sitting in a file at the custodian's office, sometimes untouched since the day you opened the account. Federal law built it this way on purpose. Under ERISA, the Employee Retirement Income Security Act of 1974, and under the contract rules that govern IRAs, the beneficiary form is treated as a binding contract between you and the institution holding your money. A will is a public legal instruction aimed at a probate judge. A beneficiary form is a private contract aimed directly at a bank or brokerage, and contracts move faster and hit harder than court instructions ever will. When you die, the custodian does not read your will. The custodian does not call your children. The custodian pulls up the beneficiary form on file and pays exactly the person listed on that piece of paper, regardless of what has changed in your life since you signed it. Carol updated her will after her divorce. She updated her insurance. She never once called her 401k provider from her old job to remove her ex-husband's name from the beneficiary line because nobody told her that a 401k lives completely outside of a will. Her daughter hired a lawyer. The lawyer explained, gently, that there was nothing to fight. The form was signed, valid, and legally airtight. This is not a rare glitch in the system. This is the system working exactly as designed, and it catches millions of people who assume their will is the final word on where their money goes. Divorce is only the beginning of the problem. People remarry and forget to update the form naming their first spouse. People name a beneficiary who dies years later, then never name a replacement, and the account defaults straight into probate court. People name a minor grandchild directly, without a custodian listed under state transfer laws, and freeze that child's inheritance until they turn 18 or 21, depending on the state. Some people never fill out the form at all. They assume the default beneficiary is automatically their spouse or their children. In many plans, the legal default beneficiary with no form on file is the estate itself, which means full probate, full court fees, and full public disclosure of your finances before a single dollar reaches your family. The math on this mistake is brutal and completely avoidable. Updating a beneficiary form takes most people under 10 minutes and costs nothing. Fixing the aftermath of an outdated form after you are gone can take your family over a year, drain 5 figures in legal fees, and in Carol's case, hand the entire retirement account to someone she spent over a decade trying to leave behind. Let's rerun Carol's story one more time, changing exactly one detail. 6 months after her divorce finalized, Carol sits down with her laptop on a Sunday afternoon. She logs into her old 401k account, the one she has not touched since leaving that job 15 years earlier. She clicks a tab labeled Beneficiaries. She sees her ex-husband's name, still listed at 100%. She removes it. She types her daughter's full legal name, current address, date of birth, and social security number into the 2 required fields. She adds her son as a 50% contingent beneficiary in case her daughter passes before she does. She clicks Save. The entire process takes 6 minutes. No lawyer, no notary, no fees. Carol dies at 73, exactly as before, in her sleep on the same Tuesday in March. Her daughter calls the brokerage firm 2 days later with a certified death certificate in hand. The representative pulls up the account. The form shows one name, correctly updated 6 years earlier. Within 8 business days, the entire $420,000 transfers directly into her daughter's own retirement account, tax deferred, without probate, without a judge, and without her ex-husband ever knowing the account existed. The difference between those two outcomes was not luck and it was not money. It was 6 minutes and one form, filled out while she still had breath in her lungs. That gap represents the difference between a family standing together at a funeral and a family standing in a courtroom fighting over money that should have already been theirs. This is not a rare story that happened to one unlucky woman named Carol. Every single type of retirement account carries this exact same vulnerability, and almost nobody checks it until it is too late. Your 401k from a job you left 15 years ago has a beneficiary form sitting untouched in a file cabinet somewhere in a different state. Your traditional IRA has one, your Roth IRA has one, your pension, if you still have one, has one. Every single one of these forms operates independently of your will, independently of your trust, and independently of what you told your children at the dinner table. You can have the most airtight estate plan a lawyer ever drafted, and none of it matters if the form at the custodian's office still lists your college roommate from 1982, because that was the only name you had to write down the day you opened the account. This is where most people make their second mistake. They assume that once they fill out the form one time, the job is finished forever. It is not. Life moves. People divorce. People remarry. Beneficiaries die before you do. Children are born. Grandchildren arrive. If your primary beneficiary is no longer living and you never named a contingent beneficiary as backup, the account does not automatically pass to your children. It falls straight back into your estate, and your estate goes straight into probate court, the exact outcome the form was designed to prevent in the first place. There is a second trap hiding inside this same problem, and it catches even people who filled out their form correctly. Naming a beneficiary is not enough if you name the wrong type of person. If you name a minor grandchild directly, the custodian cannot hand a 10-year-old a check for $200,000. State law freezes that money under court supervision until the child turns 18 or 21. The fix is simple. Name a custodian under your state's transfer to minors. Act alongside the child's name. Here is what you need to do this week, and every step takes less time than a phone call to a friend. First, log into every retirement account you own, every 401k, every IRA, every pension portal, and find the beneficiary section. Most custodians list it clearly under account settings or documents. Second, write down exactly who is currently listed and compare that name against your life today. If you see an ex-spouse, a person who has passed away, or a name you do not recognize, that account is a ticking clock. Third, update every single account with a primary beneficiary and a contingent beneficiary using full legal names, dates of birth, and social security numbers, because vague answers like "my children" get rejected or delayed. Fourth, if any beneficiary is a minor, name a custodian under your state law directly on the form, not just the child. Fifth, put a reminder on your calendar to check these forms again every 3 years and immediately after any divorce, remarriage, or death in the family. This single piece of paper decides who inherits your retirement money faster than any will, any lawyer, and any judge ever could. The custodian does not read your intentions. The custodian reads the form. Fix the form while you still hold the pen, because your family should be grieving you, not fighting a system that was quietly working exactly as designed the entire time. Industry estimates on unclaimed retirement assets put billions of dollars sitting stuck in accounts with missing or outdated beneficiary forms at any given moment, frozen since a custodian cannot legally release funds without a valid instruction on file. Part escheats to the state. Some goes to an ex-spouse nobody ever wanted to enrich too. None of this requires a lawyer or a single dollar spent, only 10 minutes and the willingness to open a screen you have probably never touched since the day you started that job. Ask yourself right now whether you could name, from memory, exactly who is listed on every retirement account you own. If you hesitated, that gap is the same one that cost Carol's daughter everything and in the other timeline cost her nothing at all.